Before this starts, I just have to tell everybody how good it is to see your faces.
Good to see you too, Lorinda. I think we are live.
Yes, we have 9 attendees that have come in. So welcome to everyone who is attending. We'll begin shortly.
Since this is a public forum, I'll wait until 9:30. Good morning, everybody, and thank you for attending this workshop. I wanted to welcome each of you, but I can't see each of you. I do see that there's 23 participants. My name is Lorinda Wickman. I'm currently a county commissioner, at least for the next couple months, and I'm also a former NACO president, past president from 2015, which was a great honor, by the way. And I'm a member of the Board of Indigent Defense. This workshop is sponsored by NACO's Committee of the Emeritus. The Committee of the Emeritus is a group of former county commissioners who advise and assist the NACO board. The committee was formed with the goal of preserving the institutional knowledge and expertise of commissioners who, due to term limits or other factors, are no longer in office, but who possess invaluable knowledge about county government in Nevada. The committee is currently chaired by NACO immediate past president, Lander County Commissioner Patsy Waits. In Nevada, all counties provide public defenders. NACO's Committee of the Emeritus has sponsored this important workshop today because it is believed it is critical for counties to have an understanding of how the recent reforms to indigent defense passed by the legislature will work. We also wanted to introduce some of the members of the Board on Indigent Defense, including myself and some of the staff of the newly created department. To kick us off and moderate this workshop today, I'd like to introduce NACO's Executive Director, Dagny Stapleton. Dagny currently serves as NACO's Executive Director, a tenure that began in October of 2017, following 4 years of serving as NACO's Deputy Director. Dagny has a background in government affairs, land use policy, and local government administration. On behalf of NACO, Dagny represents Nevada's counties in the state legislature, as well as before interim committees and other state bodies. Dagny has participated in every regular session of the Nevada legislature since 2009. Dagny has worked on the issue of indigent defense on behalf of NACO for the past 2 legislative sessions. Dagny has a master's degree from the University of Nevada, Reno, and received her undergraduate degree from Columbia University in New York City. Thank you, Dagny.
Thank you so much, Commissioner Wickman. Thank you for your service. Thanks for being here today to introduce us and mention the Emeritus Committee. Welcome to everyone. Welcome to all the attendees. Before I provide an introduction to the workshop today, as well as some history on the issue of indigent defense from the county perspective, I want to take a few minutes to introduce our panel and highlight the information that they will be sharing. Dave Mendiola is the Humboldt County Manager and a member of the Board on Indigent Defense Services. Dave will provide us information on how the board interacts with counties. And Dave was appointed as County Manager for Humboldt County in 2014. He brings 32 years of experience building businesses and public organizations. He currently serves on Nevada's Board of Indigent Defense Services, the Humboldt County Landfill Committee, and previously as a commissioner on the Humboldt County Regional Planning Commission. Dave graduated from Albert Lowry High School in Winnemucca, went on to earn a bachelor's degree from Boise State University and a master's in global business administration. Dave has extensive experience in corporate America after 30 years working with Eastman Kodak, Simons Medical Systems, and AGFA Givart. Thank you, as well as building a highly successful startup company that grew into a multi-million-dollar revenue generator in 4 short years. Humboldt County is lucky to have Dave Mendiola as their manager. We're lucky to have him on our panel today. Also with us today is Marcy Riva. Marcy, say hi. She began her tenure as the executive director of the Nevada Department of Indigent Defense Services in November 2019. Prior to moving to the department, Ms. Riva was an attorney for 15 years with the Nevada State Public Defender's Office in Carson, where she advocated on behalf of indigent persons charged with crimes at the trial level. Ms. Riva started her legal career clerking for the Honorable Dan Pepez and Honorable Steve Debrescu in the 7th Judicial District in Eastley. Marcy will provide an overview of the new state office, resources they provide to counties for administering indigent defense services, and the oversight the office is providing to public defenders. Jared Hickman from the Office of Indigent Defense Services also joins our panel. Jared serves as the Deputy Director of the office and began working with Ms. Riva in December of 19. Beginning in 09, he served as a Deputy Public Defender in the rural Colorado communities of Las Animas and Huerfano counties before relocating to Nevada. Since then, Mr. Hickman has worked as an appellate and trial deputy public defender with the Nevada State Public Defender and Washoe County Public Defender offices, respectively. Jared today is going to provide us an overview on the proposed standards for delivering indigent defense in Nevada. And then rounding out our panel is Lorena Dillinger. Lorena will provide us an overview of how Nye County has managed and worked with contract public defenders and what that means for indigent defense delivery in her county. Lorena is the Assistant County Manager for Nye County. She was appointed in October 16, but has worked for Nye County since April 2002 in a variety of positions. She's a certified public official and is a certified labor relations professional and is a member of the labor negotiating team for the county. Lorena has managed the county's public defender program for 4 years. So thanks to all of the members of our panel for being willing to join us today. Also, before we begin our official program, I wanted to provide some minor housekeeping items. We will take questions at the end of the presentation, so we'll go through our presentations first, but we will have about 20 minutes at the end for questions. So please hold questions for the end, but we'll look forward to discussing those and answering them as well. This workshop is eligible for credits under the Certified Public Official Program. If you would like to receive credits, if you're in that program, please reach out to Amanda and she can get you the form to do that. This workshop is being recorded and we will post a link to it on the NACO YouTube page. So if there's someone from your county who was interested in coming today but unable, they're able to watch the workshop after the fact, and so that resource will be available for you or any of your fellow employees or commissioners, and please do share. And then finally, I want to thank the University of Nevada Cooperative Extension as a great partner to counties. And in this instance are our heroes, as they are helping us with the technical side of this workshop today. This is actually a practice for our virtual annual conference, which will take place November 17th to the 19th. Please sign up. It's going to be a great virtual time. Joe Lednicki is an awesome, special to us hero from Extension, and he is helping us with the technical side today. So I want to give him just a quick minute to go over a couple technical things for the attendees.
Hello, I'm an economist with UNR Extension in our Community and Economic Development Program. Thank you everyone for attending. As Dagny said, just a couple of technical facilitation items here. The chat is disabled currently. However, if you do have any questions for the panel, we will be answering that at the end of all of the presentations in total, but you may ask the questions at any time during the presentation with the Q&A function in Zoom. We won't answer them right away, but they will be logged there and we will get to all of them that we can at the end of the presentation. But that is all I have, so thank you very much.
Thank you, Joe. Okay, well, I will go ahead and start with an introduction to this topic from the county perspective. Of course, the most basic part of this topic, of all of this, I think that everyone knows, is that the Sixth Amendment of the U.S. Constitution assures the right to counsel and says that in all criminal prosecutions, the accused shall enjoy the assistance of counsel for his defense. Gideon versus Wainwright then was decided by the U.S. Supreme Court in 1963, basically said that the right to counsel applies to all indigent defendants in all criminal cases. Gideon also established that the provision of the Sixth Amendment right to effective assistance of counsel is an obligation of the states, not local government, under the Due Process Clause of the 14th Amendment. Nevada, interestingly enough for us here in Nevada, was actually one of the first states in the nation to provide for lawyers for those who could not afford them, all the way back in the late 1800s. So historically, our state, and in this case originating in a rural county, Lander County, was a pioneer in this arena. As many who have been involved in this issue over the years also will know already, though the state had a strong Office of Indigent Defense and provided attorneys throughout the state of Nevada in the 70s and 80s. Since then, and before that, and since then, state funding to provide those lawyers to rural counties has been continually eroded, and costs to counties have steadily increased. This has happened to the point where, over the last decade at least, counties were finding that the state was failing in its duty to provide public defenders. It was a long way to travel, and counties were seeing rural defendants sitting in their jails without sufficient representation. So in frustration, rural counties stepped up to meet this need and began, even at additional expense, taking it upon themselves to provide public defenders. Today, only Story County and Carson City use the state public defender, and only for a portion of their services. Statewide, almost 100% of the total costs of indigent defense are borne by counties. And this is despite the fact that it is a state responsibility to provide indigent defense. So recently, a few years ago, the ACLU sued the state of Nevada on behalf of rural defendants that they believed were not getting sufficient defense. Though it was counties providing that defense, the ACLU, rightly so, took the position that it was the state responsibility to provide indigent defense, and so it was the state who was legally liable for any failings to defendants. And of course, the state who then was responsible for supporting the counties in the provision of indigent defense. That lawsuit has since been settled. An additional important piece of history on this issue is that NACO, that lawsuit has been settled following AB 81, which I'm going to go over, and the creation of the board and the department, as well as other provisions. So an additional important piece of history on this issue is that NACO and county representatives have been involved in efforts to reform indigent defense for years. The Supreme Court's Indigent Defense Commission was established in 2007. That commission had multiple county representatives on it, a handful of which also participated in a rural subcommittee regarding indigent defense. Also, 4 sessions out of the last 6 legislative sessions, NACO has carried legislation seeking reforms and additional funding for indigent defense. AB 81, I want to note, was not one of those bills. That was not a NACO bill. The Supreme Court's, finally, in part as a response to the ACLU's lawsuit leading into the last legislative session, in 2018, there was a state committee tasked to look at the issue of indigent defense reform and propose solutions. Due in part to the advocacy efforts of NACO and others, the makeup of that committee was a majority county representatives. Our position is that because counties are currently in every county providing that service, it should be counties who have a strong voice at the table on any reforms. So it was that committee and others who worked on legislation last session, and that was AB 81. That was the Indigent Defense Reform Bill that was passed. That bill created a new regulatory body that will oversee, that does oversee county public defenders in Nevada. That body is the Board of Indigent Defense Services, which we will talk about more, and which we've already mentioned. Commissioner Wickman, who introduced today's workshop, is a member on that board. And I also want to acknowledge that Carson City Mayor Kroll, who sadly just passed away last month, was the chair of that board. His passing was a loss to many in Nevada and many organizations, including to the Board on Indigent Defense Services. So the bill, AB 81, also created a new state department, the Department of Indigent Defense Services, tasked with providing services to the counties and support for their public defenders, but also oversight and training of public defenders. There are counties that over the years expressed to NACO an interest in this type of assistance, as they admittedly had little experience in this realm, including for managing public defender contracts and ensuring that those services were being delivered. AB 81 provides a check on the oversight authority of this new state department by putting them under the purview of the board. So importantly, like the board that helped propose some of the provisions of AB 81, the Board of Indigent Defense Services has a majority county makeup. So out of 13 board members, 7 of those are chosen by counties or will be county appointees. So that's a majority of those members that oversee the department are county folks. AB 81 also, of course, included mandates for reforms. This is done primarily through the creation of minimum standards that are to be met by counties, by county public defenders. The board will also oversee the creation and implementation of those standards, oversee the work that the department is doing for the implementation and enforcement of those standards. Finally, one other critical thing that AB 81 did was clearly articulate that it was the state who is responsible for any additional costs for indigent defense in Nevada. So the cost for the reforms set out in the bill, as well as for any mandates and assistance provided by the department, is to be borne by the state, not by counties. Part of how the bill ensured that counties shouldn't bear any additional cost was by allowing the board to set a cap on county costs, so that county costs could not increase more than what any county is paying today for indigent defense or to their public defenders. As a part of this structure, staff in the new department will work with each rural county to collect info on caseloads, salaries, and other aspects of their current system, and also provide them assistance in writing a plan for how their county delivers indigent defense. Finally, it is also important to note that counties have the ability, if all else fails and standards are in place without funding, to transfer the service back to the state and not pay any additional dollars. In that case, unlike in past decades, the state would also be mandated to provide effective and thorough representation of indigent defendants in rural counties. Well, that's always been a mandate, but we think that this somewhat eliminates the risk that the state service going forward would not be provided effectively if for some reason a county got to that point. On the other hand, if a county does not cooperate with the new system, the executive director may recommend to the board that a county be required to transfer their public defender responsibilities to the state. However, any required transfer must also be approved by the boards, and the board's decision is final. So part of the work that we did in advocating for counties on this issue, part of the work that NACO did and our members who were involved, was to ensure that in exchange for additional requirements for public defense in Nevada, there were also checks and balances, and that counties were a central part of those checks and balances, and that there were mechanisms to ensure funding, assistance for counties, and a way to, if all else fails, get out of the system altogether. NACO and others worked very hard on this issue to make sure that counties are a part of the structure and have a role in assuring that the reforms do not turn into an additional unfunded mandate for counties. So AB 81 was signed by the governor in June of 2019, and since then the board has convened and begun its work. Staff in the new department has been hired, and many in your counties have likely begun to receive outreach and have begun having conversations with that staff, with Marcy and her folks. During this workshop today, we will go through what Nevada's new system is, the role of the board in the department, the county role, as well as what the new standards may be. We will also introduce you to some of the board members and department staff, which we've done already, and then of course answer any questions you may have. So that concludes my introduction and summary, and I will turn it over to Manager Mendiola.
Thank you very much, Dagny. And first of all, my thanks to you. Dagny is, for those of you who do not know Dagny, is amazing. She does a lot of work for the counties and is always at the forefront of any issues and willing to help however necessary. So can you everybody see my slides at this point?
You need to switch between your
Yeah, I got a display settings here. Hang on one second. I thought I had it set up perfectly, but apparently not. So what we're going to do here is, let me get this changed. Hang on one second, we'll share again here. Well,
if you go to the top of the screen where it says display settings, the little arrow next to that. Yeah, if you click that, then there should be a switch between, yeah, the swap presenter view.
There we go. Thank God we practiced this beforehand, huh, folks? So, so my job today is to talk a little bit about the county view of indigent defense services. And, you know, I want to point out, I mentioned Dagny. You know, I've worked quite a bit over the last year and a half, 2 years on indigent defense. Part of it was due to the fact the ACLU lawsuit was in progress. We in Humboldt County were trying to do everything we could to make sure that, you know, we had a model in place that was working, and it has been. And so when all of this came about, we really did identify a lot of areas where we needed help. And as it turns out, the Department of Indigent Defense Services will really be key to helping us and assisting us. And I truly believe, as also a member of the Board for Indigent Defense Services, that this will really be a benefit to our counties. And so I'd like to kind of, first of all, start by identifying how you're going to be supported. For those of you who are in, or if you're an attorney for the county or doing contract work for a county or a public defender, you know, I know everybody has a lot of questions and concerns. And what I would suggest to you that this board, as well as the department, Marcy, Jared, and Patrick, are really here to support you in any way possible to make your operation optimized. So I want to start by talking about the members of the board that are county officials. And these individuals have vast experience in indigent defense, county government, legal services, and government finance. That's probably where I come in. I'm looking at it from a finance standpoint. I'm not a legal mind, and I love it. I'm very much interested in it. At one time, thought I would go to get a law degree, but never pursued that. But so I've always had a kind of a passion for it. So that's one of the reasons that I was willing to jump on board early, because I wanted to get involved, because I feel very strongly about indigent defense. But one of the people, Jeff Wells, Assistant County Manager for Clark County, if you look at his bio, has a tremendous amount of background in government, first in Colorado as a state legislator, but more recently in Clark County, working on many different fronts on the legal perspectives for Clark County. And Jeff is just a wealth of information. Joni Eastley is a former county commissioner for Nye County. Joni and I first met several years ago. And I found out very quickly that Joni is very vocal, passionate about protecting her county, that things are being done correctly, and that her county benefits from any actions by the state. So I love having Joni around, because she lets you know when you're in line and when you're not. And Lorinda, I want to thank current county commissioner for Nye County, and Lorinda just does a great job, you know, past president of NACO. And again, another individual who really cares about her county and is watching this specific board as well as this department to make sure that we really are driving value to those counties. Drew Christensen is the Director of Office for Appointed Counsel in Clark County. If you look at, again, Drew's bio, this is a gentleman who's got a lot of background in the legal system, truly understands the ups and downs, the potholes where they lie and how to fix them. And so he's a guy that we'll all draw on for information and direction. Kate Thomas, Assistant County Manager, Washoe County. Kate's very strong on the financial side. We will all call on Kate to make sure that counties are being represented properly and that financially they're being protected. Robert Tellis, Public Administrator out of Clark County, and of course myself, County Manager here in Humboldt County. And so with this group, I think the important thing to understand is that the expectation are these individuals are looking out for the interest of counties and to ensure the intent of the law, and that the policies will in fact improve indigent defense without adding greater fiscal impacts to the county. So I would really recommend to any of you to reach out to any of these individuals or to Marcy, Jared, and or Patrick. If you have a question, you have a concern, get those in front of us. We want to hear from you. We'd love to hear your perspective, and we'll go to bat for you. We just need to understand what your concerns are and what the challenges are. So let's talk a little bit about how DIDS works with rural counties. Primarily, they're designed to assist the counties with a county plan. Part of the law requires that a county have a plan to deliver indigent defense. And, Marcy and her team are ready to help in putting those plans together if you don't already have one, and or to look at those, revise them, and bring them up to speed. Also on the front of indigent defense for continuing education credits, they're going to assist in that area for practitioners. And that means both the contract attorneys and the county employed public defenders. This was something that I heard a lot from county public defenders, really trying to understand a better, more focused effort to get public defenders training. And so this is an area where they will focus very hard. They've already put together quite a few programs that they're offering, and that will just grow over time. The other part that's
Dave, this is Dagny. I'm going to interrupt you real quick. I just want to make sure your slides are advancing and that we're seeing what you want us to see.
Okay, well, let's see. I'm looking. Let's see. I'm on slide 3, and that should be. It says assist with at the top. Or
Can you restart your screen share, Dave? It seems to have frozen on our side.
Sure.
Oh, there we go.
Try again. You have that now?
Yes, much better. Thank you very much.
So let's make sure that I'm on the right one here. So I believe this is where I was. The last line should be with third-party attorneys, contract attorneys.
Yep, it looks good. Thank you, Dave.
Okay, you're welcome. Thanks for jumping in there. So bottom line here is Marcy, Jared, and her team are there to help you with third-party attorneys, both from recruitment of those third-party attorneys to the actual agreements between the attorneys and the counties. So if this is an area where you've not done it in the past and you're looking forward to doing it, you can get involved, or if you want to improve the contract to make sure that it covers the things that you need and covers both parties, they're going to be there to assist on that front as well. So in addition to that, they're going to be working with rural county-based public defenders and contract attorneys on weighted caseload studies to ensure that proper resources are being provided to meet the established standards. This is a really important item here because we really do need the input from all of you attorneys out there working in the public defender realm, and to get this right. This is a project that's just launched. There's an advisory committee, which I'll talk about here in a minute. And we really do need a lot of input from people as we go through the weighted caseload study to truly understand what we're trying to wrap our arms around. So I would really recommend that everybody jump in and help where you can, and we will reach out to you as well. Also to assist with capital murder cases where rural public defenders offices or contract attorneys do not have the expertise or the experience or the time or the funding. This is always a problem in rural America. For example, just last year here in Humboldt County, we had a capital murder case that we believe was going to cost us about $500,000 for the entire process of the trial, investigative work, etc. And of course, for any rural county, that's a big chunk. And it would have been fairly devastating to our budgets. But fortunately, that was settled out of court, never went to court. And so we didn't have to go there. But here's a case where, whether it's the financial issue or whether our public defender was experienced enough or willing to take that on, this is something that we can turn over to the state. They can bring their folks in, and that's important, so that you're not left out there in the lurch. And most important is that we get the client the defense that they deserve. Also, I mentioned we're conducting the weighted caseload study. An advisory committee has been formed and established, and I encourage, again, as I said, attorneys from every rural county to cooperate with the study. And again, right now we're looking for folks who want to jump in and want to be part of that. And so if you get the call, or if you're interested right now, please give Marcy and her team a call, and be sure to jump in on that, because that's critical that we make sure that we're looking at the right information, so that in the end we have a product that helps everybody. In addition, I want to spend a little time on case management. Part of the law was that the state was going to provide software, and in this particular case, the company is called Legal Server, and it's a software that will be provided to every rural county at no cost for case management. And the important thing here is this is going to help DIDS to better understand the time and resources specific to each county that is necessary to provide optimal digital or indigent defense, And so I think the important thing here is that as we do the weighted caseload study, we really want to know how it's different from county to county, because that's the one thing I've learned. It really is. One size does not fit all. And so there's a couple of things that makes this good and is beneficial to the counties. Number one, it saves the counties thousands of dollars up front for the cost of the software, as well as the implementation, and then the ongoing annual costs of maintaining that system. So that's a critical piece. The other part of it is part of, the law does require that the counties utilize the software to report their information back to the Department of Indigent Defense Services. So the critical piece is that these counties have to report in a standard format to allow DIDS to understand both common practices and customized approaches. So it's really important that everybody take a hard look at Legal Server software. I've had several discussions with Legal Server. A good part of my career in the private sector was selling software and implementation of software applications. And for the most part, pretty much every software can be integrated to some degree. I'm not saying it's full integration, because they all look a little different. But in the end, I think it's really important that every county take a hard look at Legal Server, even though you may already be down the road on something else or be using a different product, because in the end, the law will require you to report that information back to DIDS. And so, and then it's going to fall on that individual county, if you're using a different system, to provide that information in the proper format, because indigent defense does not have the resources to take information in one form and put it in a different form. So I want you to just keep that in mind. I think that's very important. So I think I've covered all of the things that I believe are very, very important, and all the benefits I think that the Department of Indigent Defense Services brings to the counties. And I'm very excited to work with Marcy. I know they are really hard work, and I spent a lot of time on the phone with them, and I'm very excited about the individuals and the team that she's assembled. So that's it for me. Thank you very much.
Thank you, Dave, so much for that. I think it's my turn to go into a discussion of an overview of our new state office. And I want to start off by letting you know we are so excited to be here today and share with you what our department is doing, because it's something that's very close to all of our hearts. Dagny, thank you so much for inviting us to be here today. You've been so helpful in the creation or the support of our department as we've gone. And I want to do a big thank you to NACO. They have provided a lot of our members, and I think we have probably the best board out there if you'd like to see any of our board meetings. So at this point, I wanted to share my screen. Can everyone see that? Am I sharing the right one?
Yep, you're good. Thanks, Marcy.
Looks good, Marcy.
Okay, so as Dagny said, we were created by AB 81, and that was codified into NRS 180. So as we go through this presentation, we will be citing the law if you would like to look up where we get the basis for certain things that we're talking about. But before we go into that, I wanted to take the opportunity to kind of show you some pictures and introduce you to the individuals in our department. Here's a slide where we have myself. I am the executive director for this department. And like I said, this is almost a dream job. It's so exciting to be able to build this department. I also have Jared Hickman, who will be presenting later on in this, this training, as well as Patrick McGinnis. They are the deputy directors. Patrick is the one that's traveling through the counties. He just got back yesterday from Elko County, having a visit out there. So that was a really positive experience for him. You can see Lexi in the lower left. She's the first line of answering the phone. So if you do call our office, that's who you'll be running into. Jason Colnut, he is our management analyst. He's reached out to a lot of the counties to talk to you about your financial reporting and any assistance that he can give in that realm. And then we also have Cindy Atanasio. She is our executive assistant. She helps to run the meetings, and she basically helps to run this office. So we're very grateful to that. This department, like Dave and Dagny and Commissioner Wickman have said, do serve under the department, or we report to the Board of Indigent Defense Services. And as Dave said, we want to meet all the county members. Patrick's been going out. We've been reaching out to counties to ask for the ability to have Zoom meetings or any sort of introductions. So if we haven't been able to make contact with you yet, please email us, please contact us. We will be sharing our contact information at the end of the slideshow. So we're hoping that you do reach out. So when you look at AB 81 or NRS 180, you can see that there's several requirements that the department is required to complete. We've broken this up into 3 separate areas. There's funding, improvement for indigent defense, and oversight of indigent defense. So today I will be discussing funding, which is the county maximum contribution formula that Dagny did touch upon, and the state contribution, as well as what we are doing to help improve indigent defense. And Jared will switch to the oversight, talking about the plans and our regulations that we have coming up. So as Dagny said in her introduction, we are here because the 6th Amendment ensures the protection of an attorney if you're accused of a crime. And if you look at a map of Nevada, like Dagny said, at one point it was covered by the state public defender and county public defender's offices, but slowly the counties took responsibility for indigent defense. And today it is provided in 3 ways. The Office of the State Public Defender, which serves Carson City and Story County. County offices have been formed in Clark, Elko, Humboldt, Pershing, and Washoe. And we have contract attorneys in Churchill, Douglas, Esmeralda, Eureka, Lander, Lincoln, Lyon, Mineral, Nye, and White Pine. And I have an asterisk by Churchill because they are in the process of forming a county public defender's office, and it will be open November of 2020. So prior to AB 81, one thing was consistent for Nevada, and that was that the counties paid for indigent defense services. So I provided a map of how nationally indigent defense services is provided. Basically in Nevada, the counties paid 100%, but AB 81 is shifting that. The preamble to AB 81 says, although various counties in the state have accepted a large part of the responsibility for the provision of indigent defense, the state remains ultimately responsible for ensuring such indigent defense services are properly funded and carried out. And as Dagny said, one thing that our board is able to do is to create certain regulations, and NRS 180.320 subsection 3 says that the board shall adopt a regulation to establish a formula for determining the maximum amount that a county may be required to pay for the provision of indigent defense services. And I italicized indigent defense services because we will hit on the definition of this in just a little bit. So what is our current proposed regulation? I've included it here, and I do want you to know that this is not a final regulation, that we are still in the process of creating our regulations. Jared will touch upon this a little more, but we are planning on having a workshop on these regulations, and it will be set for either November 18th, 19th, or 20th. When it is set, we will have information about it on our website, but we want to hear from the counties. This current formula was supported by NACO, and how it sets forth is that the maximum amount that a county shall pay for the provision of indigent defense services during the fiscal year must not exceed the sum of the actual cost that the county paid for providing indigent defense services, minus any expenses related to capital and murder cases, if the population is less than 100,000 of that county, any case-related expenses. And that should be calculated at the average of fiscal year 2018-19 and fiscal year 2019-20, and the percentage equal to the lesser of the cost of inflation and any sort of union negotiated cost of living increase. We did add in there as well that any case-related expenses for counties in populations less than 100,000 should be a charge against the state and budgeted to the department, our department, pursuant to the plan for the provision of indigent defense services, and that would be administered by the department or a designee of the department. Also, if the county chooses, they would have the opportunity to transfer the responsibility to the state public defender for trial level death penalty cases, as well as death penalty appeals. So as we said, this is the current proposed regulation, which we will be discussing at our workshop. And if you do have input as to issues with it, please contact us. You can contact us before the workshop or during the workshop. We are listening. So as many of you know, Jason and Patrick and I have reached out to all the counties, and we did request this form. This is our county annual report. You can see on there that this requested reporting certifies at the bottom that the person filling out this form certifies that to the best of their knowledge and belief, this is correct and complete, and that all expenditures are for the purpose of indigent defense service as defined in NRS 180.004. And the counties up to this date have provided this form for fiscal year 18, 19, and 21. But what is indigent defense services? Indigent defense service means legal representation to an indigent adult who's charged with a public offense, or an indigent child who's alleged to be delinquent or in need of supervision pursuant to Title V of the NRS. So that definition doesn't cover everything that your public defenders are currently doing. Public defenders are doing more than that. For example, 432B cases, this is where children are removed from homes. Representation of a parent in a juvenile delinquency case, and involuntary commitments. These are examples of duties that are assigned to public defenders but are not included in our definition. So these duties or time spent doing these things should not be included in the annual report. And we've been working with the counties to try and get accurate numbers for this annual report. And like I said, this formula is subject to change pending the workshop. So ultimately, I should go back to that. Ultimately, what the goal is that once the counties tell us what their maximum contribution is pursuant to the formula, we'll talk to them about the plan as to how much additional funds are needed, and we would build that into our budget to request funds on behalf of each county to assist in supporting indigent defense services. So let's move on to the area of improvement. The board, again, is required to do certain things, as touched upon by Dave, that the board must require attorneys who provide indigent defense services to track their time and provide reports. The board must also create standards to ensure that attorneys are tracking and reporting this time in a uniform manner. So what the board has done is they've contracted with LegalServer. LegalServer is a case management system that will be provided to all providers of indigent defense services, primary providers of indigent defense services in the rural counties at no cost to the rural counties. Our department was able to obtain funding from the Interim Finance Committee to help support this request. We are in the process of building this software system as we speak, and the go live date is projected to be March of 2021. Another area of improvement is collecting complaints or recommendations in the area of indigent defense services. If you check out our website, you can see that we offer a portal for members of the public, and this can be done anonymously to provide complaints or recommendations concerning the provision of indigent defense services. So if you do have individuals that are coming to you with thoughts about indigent defense services, you can direct them to our website and ask them to send those recommendations or complaints to us. Another area of improvement that Dave has talked about as well is this maximum caseload standard. The board is required to set a maximum caseload standard for indigent defense services. And our department has partnered with the National Center for State Courts to perform a weighted caseload study to assist in the creation of a data-driven maximum caseload standard. At this time, we have formed an advisory committee made up of indigent defense attorneys, staff, and investigators from across rural Nevada, and they are the ones that are assisting in determining how this caseload should be done, when it should start, what we should be tracking. And I would reach out to all of the county leadership there and ask you, please encourage your indigent defense attorneys to participate in this survey. Because if we have full participation, it will create a valid data-driven standard that we can stand behind because we know everyone did it. And counties will be able to determine how many attorneys they actually need in order to deal with the caseloads that are in their counties. So please encourage your attorneys to cooperate with that. Another area of improvement was touched upon by Dave is providing training. Continuing legal education is required for defense attorneys, actually for all attorneys. And what we've done so far is we've provided virtual training monthly. We have one coming up on October 29th on the subject of problem gambling. And we have another substance abuse credit set for November 6th. These trainings are limited to rural indigent defense providers. And I see when we're looking at the list of individuals that are here today, we do have some attorneys that are providing indigent defense, and they have been actively cooperating or actively participating in these trainings. I think it's a very great thing for us to get together and be able to talk about what's going on in all the counties. And it gives the attorneys a forum to really be able to talk to each other. What we're hoping, pandemic allowing, is to have a 2-day conference at Boyd School of Law, March 18th and 19th. And our goal is to provide scholarships for the indigent defense attorneys, primary attorneys in your counties to come to that training. So we may be able to assist with the cost for them to be able to travel there. And again, these trainings are provided free of charge to the county. Another area of improvement is we do prepare an annual report. This is a copy of the front page of the annual report for fiscal year 2020. We publish data that's been collected. So if you go and you check out this, one thing that should stand out for you is at this point in time, counties are not collecting data in a uniform manner. And some counties aren't necessarily collecting data at all. So if you go and look and compare your county to other counties, you can see that, the numbers don't necessarily mean anything yet. But if we're able to use this legal server and create reports, we'll finally get some data which can support indigent defense and making improvements, further improvements. If you look at this report also, we do make recommendations for future legislation. So we compile everything that we're collecting in this report. And if you'd like to see it, you can find it on our website. So again, another area of improvement is we do have our website. It's DIDS, Department of Indigent Defense Services, .nv.gov. Here we have news and updates of things that our department is doing, things that are coming up. We list career opportunities. If in your county you have any sort of opening for an indigent defense service provider, we can list a link to it on this website so we can have one place where all attorneys could come to see what's available for job opportunities. So if you'd like to list a job there, please contact us. We will put it up there. If you'd like to find information about our board meetings or what's going on, our minutes and our agendas are listed up here. Our next meeting will be slated for November. Our October board meeting will be canceled, and our November board meeting, once we finalize the date, will be listed up on this website. It'll be that board meeting / workshop to discuss our regulations. So you can find information about it there. You can also join our listserv so that you get notice of our agendas, and when our notices are sent out, you will be automatically added to that if you join our listserv. You can see the list of the trainings that are available for indigent defense services and providers. And like we said, we've been doing those monthly and we've had excellent attendance. Contact information for attorneys. There's one set place where you can find how to contact the attorneys from the different counties, their email address, their phone numbers, and what their office addresses are. And you can also see our proposed regulations up on this website. A couple other issues that I would like to present before I turn this over to Jared is we reached out at a prior NACO meeting and we discussed the coronavirus emergency supplemental funding that's available for any sort of services related to law enforcement. We did receive notice that there are still funds in that, so we would encourage counties to apply for funding on behalf of indigent defense services. And if you'd like our assistance in any of that, we are always here to help you. We are always available, and we would love to talk with you to see how we can help you improve indigent defense in your county. So at this point, I'd like to turn it over to Jared Hickman, and he is going to discuss the oversight.
Hello, thank you, Marcy, and thank you, Dagny, and thank you, Board Member Wickman and Mendiola for the introductions. As Marcy stated, my name is Jared Hickman. I'm one of the deputy directors of the department. Specifically, where I fall into the scheme of things is essentially work with the attorneys, the state public defender practitioners in rural Nevada. It's my job to provide the continuing legal education programs, training opportunities, conference opportunities, identify and encourage best practices for attorneys, and then also to provide assistance to counties in the formation of their plan for the provision of indigent defense services, which we're going to jump into. So with that, I'm going to share my screen here and we'll launch the PowerPoint. Okay, that should be up. If there's any issues seeing that, please let me know. Okay, so the Venn diagram displayed as Marcy has previously covered. She discussed funding and improvement. What I'm going to talk about this morning are the plans and the standards regulations that are in the process of being promulgated. I want to give some specific information as to plans, provide examples, and then talk about proposed standards and regulations as compared to our organic statute. So so you know where they come from and what direction we're headed. So first off, as Marcy mentioned, we are planning a workshop on the regulations in November. We are looking at 3 possible dates, the 18th, 19th, or 20th. We're currently checking with our board members to look at availability. Once that is determined, the date will be posted on our website, as Marcy mentioned. And then finally, a copy of the draft of proposed regulations can be found on the website under the regulations tab, and the link is down here at the bottom. So any questions or any review of those regulations can be done there. So the plans. The plans come from the statutes regarding county public defenders, specifically NRS 260.070 subsection 2. And that statute provides that annually the Board of County Commissioners must provide a report to the department that includes the plan for the provision of indigent defense services for the county for the next fiscal year. But that's not a defined term or phrase within the statute. So it begs the question, what does it mean exactly? Well, we're looking at a couple of things. Generally, as kind of a broad stroke, a plan is how the county provides indigent defense services and follows the regulations of the board. So things that we're looking for that will be in the regulations are the county's processes for selection and appointment of counsel, the county's processes for screening for indigency, the approval and payment of trial-related expenses such as investigators and expert witnesses, payment of the attorney's qualifications of counsel. A really good example that's currently in place right now is Pershing County Code Chapter 2.80. The county code is certainly a way to lay out a plan for indigent defense services. When you look through Pershing County's code, it discusses how the public defender office there is created. It creates tiers of conflict counsel and describes how they're appointed and how they're selected. It provides qualifications for the public defender and the conflict counsel. It provides the mechanisms for payment of expert witnesses and investigators. It provides standards of representation, including counsel at first appearances and interviews with the clients. It includes plan can be laid out, and it incorporates all those things that we're looking for and all those things that.
Jared, one moment. I think you're breaking up a little bit. Can you try speaking again, please?
Sure. Are we there?
Yeah, that sounds better. If you could just go back about 15 seconds from what you were saying.
I'll start. I was discussing the Pershing County Code Chapter 2.80 as an example, and what it contained. That list of ordinances provided how the public defender office was created, how the tiers of conflict counsel were created, how they're selected, how they're appointed, the qualifications for attorneys, the mechanisms for payment of trial-related expenses, the standards of representation, including counsel at first appearances and initial interviews with clients, reporting data, and how the county makes its indigency determination. So their ordinance lays out all those things, and is a good example of I guess what a plan is. So the next question is when it's due. The statute provides pretty straightforward on or before May 1st of each year. All this kind of, to me, begs the question of why. Why is a plan necessary? Well, it provides some structure. It provides structured information gathering, deliberation, and decision making. But I think most importantly for the county, it provides identification of necessary cost that would be provided at state expense. So once the cap is in place, anything that is needed to comport or follow the regulations would be identified in that plan and sent to the department for either budgeting process or pulling from the interim finance committee. But there's also some other benefits. The federal system operates under the Criminal Justice Act, and that act requires plans for the provision of indigent defense. And recently they released a report, 2017. It's the report of the Ad Hoc Committee to Review the Criminal Justice Act, the Cardone Report. And in there's a discussion of the benefits of plans, and those benefits included that they are essential to creating knowledgeable, experienced panels of attorneys, structure for admitting and removing attorneys, and structure for promoting culture within the indigent defense community. So all those are benefits that the federal system derives from their plans, and I think would be applicable here as well. So the last little portion of that slide is it too much, or are there questions? Well, it's also our duty to assist counties with making plans. So if there's questions about plans, how they should be written, or what format they should take, what should be in them, as Marcy indicated, we're here to help, and in fact, that's one of our duties identified in NRS 180.430 subsection 4, is to assist with plans, including the estimation of costs. So we are available for that as well. So that moves us to the regulations. I guess the first question is why regulations, and I think again the most important thing is it's tied to funding. Once the regulations are promulgated, when you look at the series of statutes in 180.430 and 180.450, any additional funding that's required to comply with or follow the regulations over and above the county cap is to come from the state. So the tie-in with the funding is critical. but also because the statute requires the board to promulgate those standards and regulations. So where do they come from? NRS 18320, I've kind of referred to as our organic statute. It really outlines the duties of the boards, and we're going to follow that. That's going to become the path that we follow going through these slides. Subsections 2 and 3 contain specific grants of rulemaking authority. Subsection 4 contains a general but limited grant of rulemaking authority, and that's that the board has the board can adopt any additional regulations it deems necessary or convenient to carry out the duties of the board and the provisions of the chapter. So although general, it is tied to carrying out the functions of the board. So here we go. We'll start with NRS 180.322A. There's not a whole lot of songs that talk about economic disincentives and constitutional requirements. So we'll head this one off with just the statute itself. That provision requires the board to establish minimum standards for the delivery of indigent defense services to ensure services meet constitutional requirements and do not create any type of economic disincentive or impair the ability of the attorney to provide effective representation. So what these will entail are prompt indigency screening, counsel at first appearances, client interview, the initial interview with the client, and the ability of the county to provide the resources or settings necessary for confidential client communications, access to resources for investigators and experts where those are reasonable and necessary, effective counsel. So we're supposed to set out CLE and training opportunities as Marcy has discussed, and we'll touch on that here in just a little bit. Attorney compensation and contract requirements, providing the required terms of the contract that do not create economic disincentives. And then finally, that's all tied in with a review process. The review process that will be proposed will include, well, let's put it this way. Dagny had discussed a little bit about the takeover provisions in NRS 18450, where in the instance a county is not following the recommendations or the regulation standards of the department and board. The review process includes notice of the on-site review, a report that goes to the county to provide findings, an opportunity to respond, and so that way there's a process of notice and response, and an opportunity to take whatever action may be necessary, short of just going right to the corrective action plan that it's outlined in NRS 180.450. So that way everyone's on the same page and knows what's happening in that process. CLE and experience requirements. The statute specifically requires the board to adopt CLE requirements and experience for attorneys who provide indigent defense services. Right now, the proposed regulations include a minimum of 5 hours of CLE that's relevant to the provision of indigent defense services and provides a definition of what is relevant to indigent defense services. As Marcy stated, we are providing those courses. We're providing at least 1 hour per month at this point, and we have an eye in March of next year, pandemic permitting, to provide a conference that would cover most, if not all, of the yearly CLE requirements, and a scholarship that would get attorneys there at no cost to themselves or their office. The qualifications based on experience, the general proposed standard on that is that an indigent defense provider's ability, training, and experience shall match the complexity of the case. The statute does require specific experience qualifications. And essentially how we've approached that is to take the Supreme Court Rule 250, which provides the experience qualifications for counsel in death penalty cases. And then we've looked at the Clark County experience requirements for their appointed counsel and the Washoe County experience requirements for their appointed counsel, and kind of work backwards. Obviously the goal is to not provide any type of experience requirement that is in excess of Supreme Court Rule 250 and work backwards. So that's where those have been derived from. There is kind of one limitation in scope as to requirements on experience and provision of CLE or completing the CLE, and that's contained in NRS 180.430. One of the department's jobs is to develop and maintain a list of eligible providers in counties less than 100,000. So there will be an application process, and that statute particularly limits or specifically limits that scope to rural counties. So that's why that limitation will be there. So the next two slides are related. Both Dave and Marcy have hit on this, have discussed this in some detail. I'm going to go into a little bit more detail on kind of the finer points, but the statute does require that the board adopt regulations regarding requiring attorneys to track their time and provide reports. And in the next slide, uniform data reporting. So that's where those particular proposed regulations will come from. In terms of the timekeeping, that's useful, obviously, in the first instance for the workload study that's being conducted, but it's also useful for a number of other things. It's useful for attorney supervision. It enhances the ability of a manager to look at and evaluate the performance. You can look at frequency of client contact, the usage of investigators, social workers, or experts. You can look at motion practice. But I think most important to the group we have here, it also allows for budget and resource justification and the effectiveness of change that happens within a county or an organization. When you know how much time generally goes into a case, you know generally how many attorneys or other staff that you need, and it provides for more accurate budgeting, more accurate resource dispersal and justification, and also assist in policy changes as well. The areas of timekeeping that we're looking at will be in-court activities such as, general hearings, evidentiary hearings, trials, out-of-court activities, reviewing a file, meeting with a client, meeting or talking to witnesses, consultations with experts and investigators, and then also the amount of time that an expert investigator staff or puts into a case, and then, if applicable, the amount of time an attorney spends in private practice. So that's kind of the sum and substance of what the proposed regulation regarding time tracking looks like. Also tied into this, as Marcy had mentioned, is uniform data collection. The statute does require that the board adopt regulations to ensure that attorneys providing indigent defense services track and report information in a uniform manner. And some of the things we're looking at in those proposed regulations are providing some definitions. For instance, what is a case? Cases can be tracked a couple of ways. I think the most common way is to count each charge as a case or count each charging document as a case. And the proposed regulations provide some definition as to what a case is. Also, what kind of case is it? Is it a category B felony or is it a misdemeanor? How does the case get resolved? Is it dismissed? Is it resolved via plea? Does it get diverted? Does it go to trial and result in a conviction? Does it go to trial and result in an acquittal? And then how much time goes into that? Again, the point is to know how much time and resources are expended. And as Marcia indicated, legal server is being extended to counties at no cost to assist in those functions. The time tracking occurs within legal server. You can put legal server on phones and other devices so it can be carried with you to track time. And it also allows for some real-time reporting. So if there's a question about a specific area or a specific attorney, it can be a report can be pulled up in real time and kind of obviates the need for a paper filing on a monthly or quarterly or yearly basis. Also, something that was touched on by both Dave and Marcy are the guidelines for maximum caseloads. The board is required to adopt regulations to establish guidelines for determining maximum caseloads for attorneys that provide indigent defense services. The general standard that is being proposed is that workloads of attorneys providing indigent defense services shall allow each attorney to give each client the time and effort necessary to ensure effective representation. and those guidelines will be driven by the workload analysis. We're currently looking at providing a rural workload analysis with the National Center for State Courts. And then as the department progresses, we'll be looking at specific numerical guidelines for urban counties as well that will inform them the same things that we're looking for in the rural counties. And that's generally how much time goes into a case, how resources should be requested and justified. Vertical representation. So NRS 18320 also requires the board to adopt a regulation requiring the department in each county that employs or contracts for indigent defense services to ensure to the greatest extent possible consistency and representation of indigent defendants, so that the same attorney represents a defendant through every stage of the case without delegating the representation to others. So what that means is that the same attorney represents the same client from beginning to the end of the representation to the greatest extent possible. A couple of points that come out of that. First, the proposed regulation tracks the statutory language. So there's not going to be anything different or new there. Second, there is some language that provides some flexibility to the greatest extent possible. That recognizes that in every system of providing indigent defense services, vertical representation is not possible 100% of the time, and provides some allowances for rotations of attorneys to provide specific aspects of the representation when necessary, such as representation at the initial appearance. So there's some flexibility built into that. But that also ties in one of the regulations deals with, one of the proposed regulations deals with terms of a contract and the limitations on substitution of counsel, and that's where that comes from. It's all in an effort to ensure vertical representation to the greatest extent possible. And then recommendation for trial expenses, and when we say trial expenses, those are alternatively referred to as case-related expenses. They include expenses for expert witnesses, investigators, things necessary to present a defense. The goal here, again, it's a recommendation. NRS Chapter 7 provides the current state of Nevada law with respect to requesting these types of expenses. So this is a recommendation, but it seeks to provide some level of independence from the judiciary that's consistent with retained counsel and a prosecution. So the recommendation for Public Defender's Office is going to be to create a budget for such expenses within the Office of the Public Defender, subject to the administration of the Public Defender. That head of an office would be responsible for its administration and accountability for that. For the contract delivery system, the recommendation again is to provide a budget independent of the judiciary to be determined by the department or the department's designee, and include a mechanism of judicial review. And that's consistent with the model plans for the urban counties that came out of the ADKT 411. Essentially what happens in Clark and Washoe is that there's an administrator of appointed counsel that provides a recommendation to the court as to whether or not a request for trial expenses should be paid or not. And then ultimately the judge has the final say. So that's where we're at in terms of making this particular recommendation. The other recommendations that come out of the statute are there's two. The first is working with the law school to determine incentives to offer to law students and attorneys to encourage indigent defense practice, especially in the rural areas. In our annual report, we worked with 3 students from the law school who provided 3 recommendations. Externships, like a summer internship or externship, where a student works under the student practice provisions of the Supreme Court rules in a public defender office or with even a contract public defender. The second idea would be the Rural Law Center at the Boyd School of Law. And that recommendation was based on the Wyoming School of Law Rural Law Center, and that provides research services, writing services, to attorneys in rural centers on frankly, a few aspects of law, not just criminal law. But it's a way to get students engaged with actual practitioners. It's a way to provide resources to rural practitioners. And then finally, the third idea is the statewide Indigent Defense Conference, and we are taking steps in that direction, as Marcy had indicated. Under our obligation to provide CLE and training, we're looking at hosting a conference in March of next year, and details will be forthcoming on that soon. But that is a way to get rural practitioners together, get their CLEs, and encourage the exchange of ideas, and make some connections within the rural communities. And then finally, the last part of that statute is the obligation to review laws and recommend legislation to ensure indigent defendants are represented in a constitutional and effective manner. Those will be contained in the annual report. Marcy touched on that, so I'm not going to go into too much more detail on that. But any review and recommendations will be contained in that annual report and presented to the legislature in our bill draft request process. So our final slide is our contact information. As Marcy has indicated, I think one of our primary functions is to be a resource, to provide assistance where we can, whether that's to a county, an attorney, a court, whatever the case may be. We're there to provide assistance. And so here is our contact information, including telephone number, address, and our email addresses. If you ever have, if there's ever any questions about plans, even if it's an attorney that just wants to discuss a case and get some ideas, we're willing and able to do that. So with that, I really appreciate NACO giving this opportunity to participate in this workshop. Thank you very much. And we look forward to meeting and speaking with all of you.
Thanks, Jared. And thank you, Dagny, Vince, and to Amanda for inviting me to present for this really important workshop. I am going to discuss Nye County's public defender program and working with our contract public defenders. And I'll start with history on our public defender program. Back in 1993, our commissioners recognized that there were deficiencies in how services were being provided in regards to public defense. And at the time, the county utilized the state public defender's office, and there was only one attorney assigned to Nye County, and we had 5 courts covering over 18,000 square miles. In addition to that, he also covered Esmeralda County. This caused several challenges for the county. If there were cases and court dates scheduled in Pahrump, he would have to travel from Tonopah to Pahrump, and sometimes he wouldn't get there, and it was causing jams for, on days they'd have to delay, they'd have to continue cases, and many times our judges would appoint private attorneys to provide the defense that our indigents needed. So our commissioners over about 4 months discussed options to provide legal defense, and they put out an RFQ, received 2 proposals, and one was from the state, of course, and we had another attorney that submitted it. Along with that, they also discussed creating a public defender department, which would mean that we employed employees, and that would create, we would have to adjust budgets for salaries, benefits, office space, etc. And that challenge also exists today. The other option that was presented was the contract model. And along with that option, there were also challenges presented. They were concerned about a lower standard of representation, and also conflict attorney costs were increasing.
Lorena, I just want to interrupt and make sure you didn't want to share any slides. I didn't know if you meant to or not yet at this point.
It's not sharing. Okay, just one moment. Can you see my screen?
No, we cannot see your screen.
We did practice this with everyone before we started, just for the attendees.
We did.
You just never know. Okay, we see it. We just need you to start the slideshow.
Okay. All right, so there we go. So I'm continuing on with the history of our public defenders program. So the Board of County Commissioners decided to notice the state of our intent to create an Office of Public Defender, and we ultimately entered into a services agreement for legal representation of indigent criminal defendants. The initial contract amount was $131,000, and annually that was renewed. The attorney that was awarded the contract eventually noticed the commissioners that he was not going to renew his contract, which at the end of his contract term, that contract increased to $420,000. The commissioners put out another request for qualifications, and we awarded that to a law firm, and that was in the amount of $490,000. And as that was renewed contractually through fiscal year 2011, increased to $550,000. Also, during that time, our conflict attorney fees increased to $700,000. We realized that we needed to restructure our program because of the increase in our legal fees, and the ultimate decision was to terminate the contract with the retained law firm. Our legal fees were at $1.2 million at that point, and the commissioners approved a new program to split the contracts into 5 individual contracts and reduce our fees by $750,000. And the reason for our conflict, you know, if one lawyer in that firm had a conflict, the whole firm had a conflict. So we were appointing conflicts more than what should have been. Our contracts are modified flat fee contracts, and they are awarded annually by the Board of County Commissioners. They're each $150,000, but we also reimburse for extraordinary costs, witness fees, and anything else ordered by the court. And now our contract fees or conflict attorney fees they vary in between $30,000 to $50,000. So it was definitely a cost savings to our program. I believe there's always room for improvement. So one of the priorities that we'd like to address is the staggering caseloads. One of the management areas that we can improve on, we have a provision in our current contract right now where we can appoint a program coordinator, and they would oversee and implement the provisions of the contract and ensure the equitable distribution. Also, we are looking into adding another public defender contract to the consortium to help distribute the caseload. Also, when we award the contracts, the board looks for professional and expertise input. And so what I'd like to do is establish an application review panel, and they can provide a recommendation or just advice to the Board of County Commissioners, but ultimately the contracts are awarded by the Board of County Commissioners. And the state oversight has been extremely valuable to Nye County. We do plan on continuing to administer the program. You know, Nye County doesn't want to completely come full circle, but we do appreciate our new relationship with the state. And, you know, I don't know if it was during the shutdown limited interaction with anybody, but I found myself scheduling meetings weekly with Marcy, Jared, and Patrick, and their support and Nye County carrying out these services has been extremely beneficial. And I've been watching as the draft standards have been proposed and discussed during meetings, and those meetings that I did have with Marcy, Patrick, and Jared were to make sure that the county was in line with the draft standards, or if I needed to make improvements with our contracts or with our program, they were extremely helpful. So I definitely recommend Dave's recommendation on taking advantage of reaching out to your board members and also to anybody there at the department. And we definitely will take advantage of requesting state contribution as appropriate, and hoping that contributes to adding another public defender to our program for caseload standards. And Nye County is ready to comply 100% with the regulations established by the board, carried out by the department. And we do believe that that's the best interest of our communities, is to follow those standards. That's what I have for our contract public defenders.
Okay, Lorena, thank you so much. Anything else you want to add to wrap up, or are you all good?
I think I'm good, thank you.
Okay, thank you. Thanks to all our panelists. What we're going to go ahead and do now is do a question and answer. And so if our panelists don't mind, go ahead and show yourselves, and we will see what kind of questions we have. I want to encourage any and all attendees to please pose questions in the Q&A button area of the Zoom. So at the bottom of your Zoom screen, Q&A, please enter any questions in there. So our first question is from Patrick Cates. And Patrick, if you're out there, I might ask to have you unmuted so that you can elaborate on this question, because I think it's important. Patrick says, our contracted indigent defense attorneys are currently under the courts. So Patrick is administrator of rural county. He has been told that the state does not want indigent defense under the supervision of the courts, and I can verify that this is true, and I know that Marcy and Jared can elaborate. Is that correct, and how do other counties manage this function? So Patrick, are you, I see.
Patrick, yeah, it looks like you've unmuted your mic, so you should be able to talk.
Patrick, what I would ask is, I think your contract should be drafted and potentially with help from DIDS. I know that's a service that they can offer as well, and they're working on a template contract, but your contract should be under the control of the commission, as I understand it. And so my question is, do you guys negotiate the contract with the attorney and then oversee and pay that contract? Or when you mean goes through the courts, what do you mean in terms of the contract or the oversight? And go ahead if you are able.
Yeah, so this is Patrick Cates, Douglas County. So the commission does approve the contracts. The courts take that forward to the commission. But when it comes to actually managing the contracts, the courts are doing that.
Okay, but who wants to take that one? Marcy or Jared, do you guys want to take that?
I can take that, because I think that kind of falls into the discussion on the plans. I think to first answer your question, Mr. Cates, and thank you for it, judicial input is very, very important in terms as to what is happening with respect to the quality of representation, in the courtroom, and that's part of the the complaints recommendations function of the department. The statute also provides the department with some, very clear, oversight responsibilities, such as on-site reviews, looking to see whether or not counsel or the service is being provided in an unconstitutional manner. But I think what we're, when we talk about the role of the courts and things of that nature, our focus is in line with the recommendations according to the statute, and that's providing, some level of independence that's commensurate with retained counsel and the prosecution. There's a number of United States Supreme Court cases that talk about, the constitutionally protected principle of the independence of counsel, and that's what we're trying to get at is making sure that counsel has the ability to conduct their defense in an independent fashion. But I think judicial input, again, is very important to the process because they see every day, how the service is being provided. So in terms of supervision, as I think Dagny has previously mentioned, ultimately, and Lorena as well, it's the Board of County Commissioners who, a county's public defender, be it contractor or county office, serves at the pleasure of. So, I think the supervision will be outlined and described in the plan. The county should be very involved, and both the department and the judiciary provide input as to performance and the delivery of the service.
So if I can just summarize, it sounds like it's a little bit of a conflict for the court to be overseeing the contract, and that the county should be doing that with support from the office if they want that support. And well, I know they're writing their plan in partnership with the office, and then as a part of the county's plan, they'll address how they're going to do that oversight. So the court provides input, but not oversight. Is that correct, Jared?
I think that's a great summary, Dagny, and thank you for that. And I would also say, Mr. Cates, we're happy to meet with you. I think we've sent an email or two, and I know everyone's really busy with COVID, but we're more than happy to come out to Douglas and meet with you, at your convenience to discuss things like this.
And to Patrick, does that answer your question? Is there any other info or any follow-up you'd like?
No, I think that gives a pretty thorough answer to my question, and I will reach out to you guys.
Thank you.
Okay, great. I see no other questions. Anybody else want to pose a question of the group? Please do so now in the Q&A portion. I have one follow-up, and then I'd like to go back to the panel and ask for any comments or follow-up from the panel. Any thoughts you had on any of your fellow panelists' presentations, anything you'd like to follow up on. We'd welcome any conversation from the panel for these last couple minutes. My follow-up is, and I should have added this in my introduction, that because Mayor Kroll did pass away, and so there's an open seat on the board, the NACO board did vote to nominate a fourth rural representative on the board. So just so everyone knows, there are 4 rural county seats on the board that NACO nominates 2, and then the governor confirms and makes that appointment, as well as then 2 from Washoe County, 1 from Clark County, and then other representatives. And so the 4th rural representative that the NACO board nominated to replace Mayor Kroll is Commissioner Bevan Lister from Lincoln County. So we're waiting for the governor's appointment on that, but we think he'll be a great addition. He's very interested in the topic and a great guy to work with and a real advocate for his county. I'll turn it back over to the panelists for any concluding remarks or conversation that you guys think is important, or questions you may even have of each other.
Dagny, Dave Mendiola from Humboldt County. I wanted to just kind of add on to Patrick Cates' question and a comment to that. One of the things I believe the Sixth Amendment group came out with in their report of indigent defense in Nevada was that a lot of, and in Humboldt County, it's true for us here as well, that the funds for discovery and investigative work has been held by the district court. And so if a public defender, which again is employed here in Humboldt County by the county, needed funds, they had to go to the district court to get that. That was, as I recall, was considered kind of awkward because, again, as a public defender, it's important that you are provided with whatever resources you need to defend that client. And so the idea would be that, what if the judge didn't give you something, then it could be seen as putting that client at a disadvantage. So what we've done is we've shifted the vast portion of that money out of the district court back into the public defender's offices so that they can make their own calls on that. However, at the same time, we still need money in that area because they do have to do things outside of that. But I just wanted, it was kind of along the same lines as the question, but a little different.
Any thoughts or anything to add to that, you guys? Marcy or?
So Dave, what was the ultimate question? Funding or?
Yeah, the bottom line on that was that was funding, because the funds were held by the district court. And so the idea, the scenario plays out that a public defender would have to go to the district court judge and ask for funds to be able to conduct an investigative work or bring in experts on subject matter, that type of thing. And so it was this idea that we've got to take it out of the district court because they're hearing the case. So you bring it back to the public defender's office and let them make that decision based on what they think is best for their client. So we shifted that money back to them and so that they can make that call.
And that's what we're recommending when you look at our plans and those proposed regulations that we're working on. Number one, again, we really want to have the input of the counties, because these are regulations we can make for Nevada to make it work for us. We have this rulemaking authority. We're listening. We want to make sure it's working for you. And like Dave said, one thing that our department can do is make a recommendation as to how expert witnesses should be paid. Many counties have it where you do have to request funds from the judge because there aren't budgets within their own public defender offices, or if you have independent contractors, there's no budget necessarily. So we will be making a recommendation in our proposed regulations that when your county is making that plan, that if you have a formed office like a county public defender or state public defender, do exactly what Humboldt County did. Make a budget in there so the public defender doesn't have to go and ask for funds. Number one, that's time consuming. If you have to file a motion, an ex parte motion for funds, that takes attorney time. You have to go file it in court. You may have to have a hearing, and that could be 1 to 2 hours of attorney time that could be used doing other things. So again, we're making that recommendation for those established offices to do that. In the case that there's not an established office, what our recommendation is that there be a budget separate from the courts for indigent defense services to be able to get those experts. And we are making the recommendation that either our department, if that's appropriate, or a designee, if there's possibly an administrator that makes sense in your county, could be the one administering that form, that it could just be a phone call saying, we need these funds for this, let's get this going. And this makes so much sense in so many ways. One of the biggest I can think of is, you know, individuals that get in trouble with the law are our community members. They're friends, family members of other people. They're people that we care about. And if they need services, the faster we can get them the services, the better off they are. If we can get them a substance abuse evaluation immediately and get them into treatment immediately, that's something that's going to be a lot better than sitting and waiting for a request for funds and then that ultimate process. Because in the end, you know, all these people are Nevadans and we want to help them as much as possible. And the quicker we can help them, the better it is. So like Dave said, that is going to be our recommendation. And when we work with each of these counties to make their plan, we hope that they have an independent source of funding. But the one problem we do have is Chapter 7 of the Nevada Revised Statute currently does say the process to be able to get funds is to request the funds from the court. So that is currently how it's set out in Nevada law at this point, but we think that plans could address this and give some independence and get those funds a lot quicker.
Thank you, Marcy. Thank you, Dave. That's a great question and a good topic, I think, to discuss a little bit and shed a little bit more light on. I don't see any other questions from attendees. Any other thoughts, questions, conversation from the panel members?
I would just like to say thank you again for being invited to talk about our department. Just like Lorena said, we've established a good relationship with Nye County. They've been calling us, emailing us, and I think that's what we're really hoping for in a lot of the counties. There's other counties we've established that relationship with too, other than Nye, but she gave perfect examples of when we're locked down in March. You know, we had weekly talks with her, which was really great. So we're hoping to build that relationship with all the counties. We are here. You have our contact information. You know, we do have new phones, so give us a call. We're ready to talk about indigent defense. We love this subject.
I appreciate that, and part of your mandate is to assist counties. So So thanks for all of your work, both Marcy and Jared, all the work that you've done in outreach and building relationships and really supporting counties, and also being sure to always make clear to everyone that it is the state that's going to pay for for these reforms, and that we all, from the county perspective, that understanding to us is really important, as well as the extra support to make sure that these services get delivered to the folks that need them and with a good quality. So thanks also to Lorena and Dave. Thank you so much for taking the time out this morning to be on this panel and provide information. We are going to post this on our YouTube channel so that at any time any of the other county commissioners or staff can access the video. And with that, we'll say goodbye. Thanks again so much, everyone.
Thank you for the opportunity.
Thanks, Dagny. Thank you.
Thank you so much, Joe, and Cooperative Extension for your assistance as well.
Thank you kindly.